Now we'll discuss Unit 5 IPR and report writing as a part of research methodology and IPR subject. First, we'll discuss some basic terminologies and differences between what is creativity, innovation, and invention. Creativity is the capability of a person or act of a person for conceiving something original or individual. Creativity is basically for making something useful which is already existing. Innovation is the implementation of something new. We will innovate something really new, and innovation is turning a creative idea into a value. Invention is the creation of something that has never been made before. So far that product or the particular thing is not existing and is recognized as the product of some unique insight. See, you can see there is a timer embedded into a medicine box. It will show time since last opened. It is showing 6 hours, 6 minutes, 12 seconds. It is not open. So embedding the timer into this medicine box, or you can see there people can sit on this fencing which is near the lake. It's like a protective compound for the lake, and it is the seating arrangement for the pedestrian, those who are walking besides the lake. So these two can be given an example of creativity, making something useful. Incorporating GPS into the phone, incorporating GPS into the bicycle is nothing but the innovation. And inventing something which is really not existing at all. Many inventions took place in the past, like telephones, incandescent bulbs, cars, internet, etc. They come under the third thing, that is invention. So this is how the three things, creativity, innovation, and invention, can be understood. In simple words, creativity is nothing but creating something interesting. Innovation is nothing but creating something so valuable that it is widely adopted. Invention is nothing but creating something useful. Now we'll discuss what is intellectual property, which is in short called as IP, which refers to creations of the mind, such as inventions, literary or artistic works, industrial designs, maybe symbols, names and images used in commerce. They all become the examples for IP. Intellectual property is an intangible property. Intangible, nothing but it's not a physical property. It is non-physical property which is not having proper shape, size, etc. So IP is an intangible property that is the result of the creativity of human intellect, and over which the owner has the monopoly for a defined period of time, maybe 1 year or 1 month or something like that. The owner has certain rights over it which are called the intellectual property rights, that include patents, copyrights, trademarks, etc. So on this IP, owner can have rights, and unless until the permission is given by the owner, unless until the copyright is transferred from the owner, nobody is having the authority to use those IPs. IP is an asset of a person, like physical asset. IP is legal concept which refers to creations of the mind for which exclusive rights are given. The owner has the right to prevent unauthorized use or sale of that IP. As I said, it is intangible, cannot be defined or identified by its physical parameters. IP must be expressed in some discernible way for enabling it to be protected. There are different definitions for IP. One of the definition goes like this. Definitions for IPR, intellectual property rights. First definition is IPR is the legal rights given to the inventor or creator to protect their invention or creation for a certain period of time. IPRs allow inventors to reap commercial benefits for their creative efforts. They will be given loyalty for their invention. Once that IP is commercialized, owner or the inventor of that IP will be given some loyalty for his creative efforts. IPR is a strong tool to protect investments, time, money, effort invested by the inventor of an IP. IPRs are the legal rights that confer an exclusive right to the inventor, creator, or his assignee to fully utilize his invention for a given period of time. These are the different definitions of IPR. So there is the importance of IPR. IPR has economic value and protected by law, and there are various reasons for accepting these rights. The objectives of IPR to grant incentive to the creator of the work, that is loyalty to the work, and IPR provides mechanism of handling infringement, piracy, and unauthorized use. IPR provides a pool of information to general public since all norms of IPR are published except in case of trade secrets. Okay, this IPR has a lot of benefits to the creator. That becomes the importance of IPR, and there are different types of IPRs. IPRs are broadly categorized into two main categories, that is industrial property rights and literary artistic property rights. Industrial property rights include creations which play an economic role in production and distribution processes. Certain innovations such as medicines, new plant varieties, or new design may be protected by patents. Variety rights and design rights come under industrial property rights. They may also apply to distinctive signs such as trademarks or geographical indicators. They are obtained after a formal procedure generally called registration. Of course, the IPRs are very popular based on their geographical indication. For example, Belgaum Kunda, Gokak Kardant, they all become geographical indicators for that particular idea. IPRs can be divided into another type, that is literary or artistic property rights, which include copyrights and related rights including music, literary works, paintings, sculptures, photographs, artistic interpretations, etc. And there are different types of IPRs, and the common types of the intellectual property rights are patents, copyrights, trademarks, industrial design, trade secret, geographic indicators. So let us see what are the different characteristics of all these IPR types. So as you know, the patents are the things which are published by the inventor. That is, the patents are awarded for innovation which satisfies the criteria of global novelty, non-obviousness, and industrial or commercial application. Patent is an exclusive right granted for that invention only. Maybe it's a product or a process. It need not be all the time a real model in hand, that is the product. It can be a process also. And there are different characteristics, of course, for the patents. Patent protection means invention cannot be commercially made, used, distributed, or sold without the proper consent from the patent owners. And patent owner has the right to decide who may or may not use the patented invention for the period in which the invention is protected. Patent owner may give permission to or license other parties to use the invention on mutually agreed terms. Patent owner may also sell the right to inform someone else who will then become the new owner. The different characteristics. Copyrights. Copyright is a legal term describing the rights given to creators for the literary or artistic works. Copyright owner has exclusive rights for applying to wide range of creative, intellectual, artistic forms or works. Novels, production or adaptation of these things is prohibited. Copyright do not protect ideas, only how they are expressed. An example is this photograph. You can see Stafford Shepherd Ferry created the Hope poster during President Obama's first run for president election. But this photo was shot by AP freelancer Many. Shepherd used this photograph without the permission of the person who has shot this photo, that is AP freelancer Manny Grace Garcia. Hence, AP demanded compensation for its use in Ferry's work. Ferry responded with the defense of fair use. Of course, he has used Ferry has used the photograph which is not shot by him, but he has not used it for any bad purpose. He has used it for fair work, claiming his work did not reduce the value of that original photograph. He has not used the photograph wherein the value of that original photograph is lost. In fact, the value of the original photograph is appreciated. So, because of this, the settlement in January 2011 was decided like a split in profits for the work. Still, the one who had shot the photograph got the profit 50%. Like that, we have industrial design, you have trademark is nothing but the brand. Example, LG, McDonald's, Peter England. Trade secret is a formula or a practice or a process. For example, our Google search algorithm, Coca-Cola, NY Times bestseller list, etc. Advantages and disadvantages of trade secret. Advantages are no need to register the trade secret, not limited in time, like patents, no disclosure, can protect unpatentable information. Disadvantage is that cost of keeping it secret is very high. Others may discover invent independently. Others may patent it. If secret is embodied in a product, it may be reverse engineered, more difficult to enforce. Geographical indicators type of IPR is the name or the sign used on certain products indicating a specific geographical location. The location could be a town, region, country. GI may act as a certification that the product possesses certain qualities, is made according to traditional methods, or enjoys a certain reputation due to its graphical origin. There are different characteristics. GI indicates that the product comes from a certain place like Gokak Kardant, Belgaum Kunda, Kolhapuri Chappal, etc. has the special qualities due to that place of origin. It's an exclusive right given to the particular community, and thus benefits of its registration are shared by all the members of the community. Difference between the trademark and GI are trademark is a sign used by a company to distinguish its goods and services from those produced by others. GI, in fact, informs consumers that a product comes from a specific place and has special qualities due to that place. Now we'll discuss what is the interpretation of data and what is the procedure for report writing. Interpretation refers to the task of drawing inferences or conclusions from the collected facts after an analytical or experimental study. Interpretation is concerned with the relationships within the collected data, which extends beyond the data of the study to include the results of other research theory and hypothesis. This slide gives brief information about why interpretation is required. It is very useful in the case of research findings, and it is the basic component in order to find some facts like what is the working principle of a particular concept, or it acts as a guide sometimes for understanding in detail. And there are various techniques of interpretation. These are the various techniques. You can just go through the slide, and this slide gives you some information about significance of research writing. So why we need to write the research articles, and how to write a research report, and what is the need for research report. So you have implemented something, you have invented something, and unless until you put it in the form of report, it's of no use. So research is done for the benefit of the society, but it has to be documented properly. So research findings should be subjected to critical evaluation and verification by others. So we need to document and write the research report, and these are the various steps in writing the report. First step is logical analysis of the subject matter, preparation of the final outline, preparation of the rough draft, rewriting and polishing, preparation of the final bibliography, writing the final draft. So these steps are discussed in detail in these slides, and I have shared these slides with you students, and we are familiar with all these steps because we are in the process of writing some technical articles, and you have written your UG project reports, and you'll be writing some reports of seminar, etc. And these are the different precautions for writing research report. For example, length of the report should be decided, and abstract how it should be written. Report must provide a ready availability of the findings. First you should prepare the layout, and then you should take care of grammatical mistakes, and you must present the logical analysis of the subject matter, and you should highlight the originality and contribution, and you should mention the objective of that study, the nature of the problem, methods employed, and analysis techniques adopted clearly in your report. So students, this completes the fifth unit discussion on IPR and report writing. Thank you.